Welcome everyone, this is Amer from U Council. A lot of people in Ontario and elsewhere in Canada lease automobiles or other equipment for their use. You at some point may have leased a car, or someone you know may have leased a car. But a majority of people do not know or understand what happens when they are unable to make their lease payment. So we will cover this specific topic in today's lecture so you can better understand what happens when a default non-payment of the lease occurs for any kind of equipment or automobile lease. We're not talking about residential leases, we're talking about automobile leases or equipment leases. An equipment lease would include anything like a printer or a TV or refrigerator or a car or airplane, any kind of equipment. So all of these equipment leases are quite similar in terms of their basic structure and what happens when there is a default that occurs. We'll begin with our usual disclaimer that this course is not legal advice, so if you have any specific questions, you should contact a lawyer or a paralegal or contact Law Society of Ontario for a referral. Now, what is a lease? A lease is a contract, and it is a contract for rent of a specific item for a certain time period, right? So the main thing you want to understand is that the lessee, the person who is renting, does not have ownership of the item that they are renting. So they can rent, for instance, a car for a day or for a week or for a month or for 5 years. It is still a rent, still a lease, and the time period is defined in the lease agreement, whether it's for a day or for 5 years. And the lessee does not have the ownership of that item. Now, in some cases, you may have the option to purchase that item at the end of the lease, and that's how the leases get complicated. But fundamentally, a lease is no different than anything that you take for rent. Now, then, as I said, the leases get complicated. So there are basically two types of leases. The first one is called a true lease. A true lease is generally when the lease term ends, you return the item. So for instance, when you rent a car for a day or for a week, at the end of that day, at the end of that week, you actually go and return that car. So that's an example of a true lease, that you pay the rent and then you return the rental item back. What happens on a true lease is that in case of any legal issues, the common law principles of contract apply. And we'll talk briefly about what those principles are, and they're important to keep in mind. The other kind of lease is called the finance lease. And a finance lease is really more like a security agreement for that item. So in other words, the leasing company, the automobile company that's leasing you that item, they really do not want that item back. And so that's the way the lease is structured. So essentially, they are financing that lease for you. So in finance leasing, the lessee has a right to purchase at the end of the lease term, right? That's sort of a general clause in that finance lease. And what happens in finance lease is that there is, in Ontario, there is an act called Personal Property and Security Act that applies in addition to common law principles of contract. And it's important because this particular act provides additional rights and obligations on both parties, and it's important to consider when there is a default, what are the options available for both parties. So the legal distinction between the true lease and finance lease for the purposes of law is important. And the court, when it's deciding whether a lease is a true lease or a finance lease, will review a number of factors in that lease agreement and then decide whether it's a true lease or not, and then apply the legal principles accordingly. So it's an important distinction and legally, and so you should understand whether you're entering a true lease or a finance lease. Okay, so we're talking about the default. So default occurs in one of the instances when the lessee, if you have rented that equipment, you are unable to make payment. So in that situation, it is termed as a default of the lease agreement. So what happens in that situation is that if a default has occurred, the lessor the leasing company is entitled to common law damages. As we said, that the usual principles of contract law would apply. So what is that basic principle? The basic principle is that if the default has occurred and the lessee is unable to make rental payment, lease payments, the court will put the plaintiff is the leasing company, in a position where he would have been in had the defendant, which is you, the lessee, fully performed his contractual obligations. So what that means is, if you have a lease of 5 years term and you are in default after 1 year, then the court is going to put the plaintiff at the end of 5 years. So that means if you had made all your 5-year payments, how much money would the plaintiff had received from you? And that's the position, that's the future position. And so the plaintiff will be put in that future position, and that means the damages against you will be the amount of the balance payment that you have not made. So that's the basic common law principle for damages. But there are two qualifications to it which are important. So common law damages are subject to the principles of mitigation and remoteness. We'll talk about mitigation today. We'll not talk about remoteness today. But mitigation is an important principle to keep in mind in common law damages. And what mitigation essentially means is that whatever are these damages that put the plaintiff in that future position, whatever those damages are, the lessor, the plaintiff, the leasing company has an obligation to reduce those damages, to help you to reduce those damages. And that's called the principle of mitigation. So common law damages are then whatever the damages are, whatever that future amount of damages is, minus whatever the mitigation efforts that the lessor has made to reduce your damages. So let's explain that by way of an example. That will probably make you understand it better. So let's say you leased a car for $500 per month for 60 months. And so, in other words, you'll be paying about $30,000 over the course of 60 months. You made 10 payments, and then you were unable to make further payments. So default occurs at 10-month period. So 50 months is outstanding, pretty straightforward. So the damages are 50 times 500 is $25,000. Less mitigation. So this is the damages under common law principle. This is the future position. If you had paid all of the money for 60 months, the lessor would have received $25,000 plus $5,000 that you have already paid. That's $30,000. But now that the default has occurred, damages are $25,000 less mitigation. So mitigation is that this lessor will now take back your vehicle and then try to find another lessee and rent that vehicle to that person. So in this situation, let's say that the mitigation occurs after 10 months, right? So the lessor is able to lease to someone else, right, for the same payments, $500 a month, after 10 months. So for 10 months you paid the money, then you were in default, lessor took it back from you and made efforts to lease it to someone else, and it took the lessor 10 months to lease it to someone else for the same $500 per month. Now what are the damages? The damages are, total damages were 50 months in the beginning because you had paid for 10 and then 50 were outstanding. And then they received the money for 40 months from someone else. So the damages now are 10 months and $5,000, right? So this is the $25,000. So $25,000, those which were the initial damages, are now reduced to $5,000. So the principle of mitigation, as you can see, is very helpful for the lessee because the damages can be reduced if the lessor is able to recoup its losses from someone else, and lessor has to make these efforts to try to mitigate those damages, right? So what happens if the lessor does not want the responsibility of mitigating its damages, right? This is an added obligation that you agreed to pay for 60 months. Now you're unable to pay after 10 months. Now the lessor has to take over this responsibility of taking the vehicle back, finding other customers, and then try to release the vehicle or the equipment. And so the lessor doesn't want that responsibility. Is there a way to get around this obligation of mitigation? And the answer is yes. And it's called liquidated damages. The lessor can have a clause in the lease agreement which is a liquidated damages clause, and which allows the lessor not to mitigate the damages. So if you have a liquidated damages clause in your lease agreement, the lessor may not have the obligation to mitigate its damages. So what is this liquidated damages clause? A liquidated damages is a genuine pre-estimate of the damages, right? The court says that it must not be an amount which is excessive or unconscionable. So it has to be a genuine pre-estimate. So in our example, the genuine pre-estimate really is $25,000 because that's the amount of money that's outstanding, less some discount because the payment is being made immediately. And so, for example, the lease agreements would indicate about a 3% per annum discount on this to justify that it's a genuine pre-estimate and not sort of a penalty, right? So in our example, so if there is a clause like that, and I'll show you an example of such a clause, and it's very common, but if the lessor puts a clause for liquidated damages, the obligation to mitigate then shifts onto the lessee in a way, right? So the lessor doesn't have to take the car back and go find another lessee so that your damages could be reduced, right? So the obligation now becomes on you. So you can go, and if the lease agreement permits, you can go and find another person who can take over your lease so that you can get out of the lease and not incur those many damages, and someone else can pay to the lessor. And hence, you notice these websites like leasebusters.com or other lease websites where the lessees who believe that they are unable to make payments or they do not wish to continue with their lease agreement go and look for someone else. So an example could be, and when you go on Lease Busters, you can find these amazing deals. So for instance, if someone wants to get out of a lease worth $25,000 outstanding payment, and if you can help them out there, you may be able to take over that lease for $20,000, and that person may pay $5,000 so that you get the advantage of a cheaper lease and they don't have to pay $25,000. So that's the concept behind all these websites. So the obligation is shifted on the lessee. The lessor doesn't have to go around looking for another lessee. So this liquidated damages clause, usually when you look at your lease agreement, there will be a clause called remedies clause. And in that remedies clause, all of these liquidated damages stuff is input there. And a lot of people would not even read it. They may not even recognize and may not even understand what that clause says. So I'm going to give you an example of a similar clause, and you'll see how complicated this may sound. Upon a default, which is one of the example is when you're unable to make payment, lessor may, which is the leasing company, may terminate the lease, number one. Number two, declare the stipulated loss value immediately due, and we'll talk about what that stipulated loss value is, as liquidated damages, right? This is what it is. So, and not as a penalty, so it cannot be unconscionable or excessive. And C, peacefully repossess the equipment without court order or without liability for entry or damage to property, or require the lessee to return the equipment to the lessor. The foregoing remedies available to the lessor are cumulative and are in addition to all other rights or remedies now or hereafter existing under this lease or at law or in equity, and may be enforced concurrently and from time to time. Where lessee is in default and the lessor exercises its rights in accordance with this clause, lessee must pay the lessor's cost of collection, repossession of the equipment, and enforcement rights, including legal costs. So it's a pretty extensive clause, and you will notice in lease agreements the clauses are very similar, and these are very, very carefully drafted by lawyers, and so you will have great difficulty in going around these clauses if you are in that situation. Now it talks about stipulated loss value and what that stipulated loss value, how it is defined. Stipulated loss value is as of the date for which it is being determined. So if your breach, your default occurs today, as of today, the rental payments and other amounts then due, whatever is due, plus the present value of all rental payments scheduled to become due for the rest of the term, that's 50 months for our example, discounted from their due dates at 3% per annum, so some discount, plus the present value of the amount that lessee is obliged to pay or that it may optionally pay to acquire all of the equipment at the end of the term, if this lease expressly gives lessee the obligation or option to do so, so on and so forth. So very, very restrictive, very, very solid clauses that you need to face. So what are the lessons from this lecture? That you, if you are in a situation where you're leasing some equipment or car, and chances are you will, then first of all, you must carefully review and understand the lease agreement, and especially the remedies clause, right? And then understand clearly your rights and obligations in the event of a default. You don't want to be in a situation where the default has occurred and now you're looking at your lease agreement and you realize that the clause for default, the clause for remedy is so strict and so harsh that you have no option and you are unable to negotiate anything with the lessor. So a lot of people are optimistic when they're leasing an equipment, either a vehicle. They believe that they'll be able to make those payments, but there are always circumstances when you're unable to fulfill your obligations under the lease. So the only way to challenge, as you may have sort of figured out, a liquidated damages clause is by showing that the clause is a form of penalty, right? So it's unconscionable, it's excessive. And this is a separate topic, and we'll cover it in a separate lecture. So hopefully this lecture gives you a sense of, to understanding better your lease agreement with respect to a default. And hopefully when you release a vehicle next time or another equipment, you have a better understanding and your ability to negotiate a better deal. Now, thank you for watching, and we look forward to seeing you in the next lecture.